guest today. I'm not the guest, I'm the host. Todd, how are you doing?
I'm doing well. It's good to see you.
I guess I've been taking too long of a vacation, huh? So welcome back.
We're glad to have you as our guest host.
Okay.
But no, it's good to be back here in the studio and taping and bringing folks information that's of interest as we talk about Milpitas real estate.
And before I forget to mention, we are on Monday, Wednesday, and Friday at 6:30 p.m. and Saturday and Sunday at 9 a.m.
Channel 26.
Channel 26. So I'm going to boot it over to you and let you introduce our guest.
Great. Well, we have the pleasure of having Gerald Cummings with us today. And Jerry, as you like to be referred to, is a estate planning and elder law attorney.
Okay.
And I know in the practice of real estate that's an important consideration in terms of how you look at your estate, and as people age,
how you hold title,
how you hold title,
correct.
And again as people age in their homes as well, there are issues that are there as well. So, Jerry, it's great to have you.
Well, thank you for having me.
Yeah, welcome. Maybe you just start off and give us a little bit of background about yourself. Where you grew up, maybe perhaps a little bit about where you went to law school and your law practice.
Sure. Well, I was born in San Mateo, and my parents moved down to Sunnyvale when I was 3 years old.
Mm-hmm.
Lived in Sunnyvale pretty much my whole life. Went to college at UC Santa Barbara. If I could have gone to law school there, I would have loved to, but they don't have a law school, unfortunately. Came back and went to Santa Clara University.
Okay.
And I'm still paying for that, as are many people. Ended up moving then to Arizona for a few years, worked in the insurance field, and came back to California in 1998. I've been practicing law since that time, mostly in the estate planning area, and pretty much exclusively since 2003 in estate planning and elder law.
Terrific. And then you have local offices that are close by here.
Yes, my office is at 1210 Park Avenue in San Jose, right off of Park and Meridian.
All right. Terrific.
So how did you end up getting into the legal profession and specifically specializing in the field that you're in now?
Well, I really made the decision to go to law school. Frankly, to be honest, I didn't like the major that I had, and it really wasn't preparing me to do anything other than go into marketing, and I didn't really want to do that. So I decided I had taken some pre-law classes in college and really enjoyed them, and decided to go to law school. The ironic part of it is, as a sole practitioner, I have to do marketing all the time. So
we all do. Welcome to the club. But
exactly. And as far as this particular field, I really wanted to go into an area where you can actually help people, where I'm not dealing with a faceless corporation and don't know who my clients are. I want to work with people that want to work with me, not that have to work with me.
Okay. All right, that's fair.
Well, good. Well, what are some of the aspects of that you really like? I mean, it's the people work, but there's specific things about that type of work that really are intriguing to you.
Well, the things that I like are sitting down with clients, showing them how it's, by doing a proper plan, whether that's a trust or a will, that we can make sure their wishes are going to be carried out when they pass away. If they own real estate, I can show them how to save a lot of money in probate fees and possibly taxes, and just really give them peace of mind knowing that their wishes are going to be carried out and that they're put down someplace.
Okay, all right. I'm a real estate broker, so I'm in just the sales end of the transactions. So tell me, what's important for someone to consider when they plan on either how they own real estate, holding title, and different ways that can affect with the outcome?
Well, there's a lot of parts to that question. The first is if they're owning as an individual and not with other people. If they're married, they can either own it as community property, which means even if their spouse is not on title, they're still entitled to half the property, or they can own as as their sole and separate property. So that's kind of, for an individual, the decisions you need to make. If there's more than one person that owns the property, there's a number of different ways that you can hold title. There's what's called tenants in common, and this is what would be very common for people that are not related to each other. And what that really means is they each own whatever percentage they've purchased of the property, 50-50, 60-40, whatever they've agreed on. And when one of them dies, they can then give their 50% interest, their 60% interest to whomever they want to.
Okay.
Child, the next door neighbor, the person that's on title, anybody they want to. They're free to give it to whomever they want. What's very common for people that are married or in relationships is to own as joint tenants. And what this means is when one dies, the other joint tenant automatically receives the property. There's some paperwork that needs to be filed with the recorder's office, but it's basically automatic.
Tax consequence for that?
For a married couple, actually there are going to be some potential tax issues, but let me talk about community property, and then we'll get back to the tax issues. For married couples or even domestic partners that are registered, you can own as what's called community property. California is a community property state, just like most of the other states that were at one point Spanish territories. And that just simply means that the community owns the property, and when one spouse dies, the other spouse will receive the community interest, the other person's interest in the property. The tax advantages come in the way the IRS classifies community property. When someone dies, their house gets a new tax basis, and that's whatever the house is worth on the date of death. So as an example, someone bought a house for $100,000, they die, it's worth $6,000, the basis now becomes $600,000, and so if they sell it later, or if their children or heirs sell it, any capital gain is going to be based on the $600,000 figure. So if they sell it for $700,000, there's a $100,000 capital gain.
Okay.
With community property ownership, when one spouse dies, the entire property gets a new tax basis. So again, a married couple bought a house for $100,000. The husband dies, it's now worth $600,000. The tax basis now becomes $600,000. So if the surviving spouse sells that property and they sell it for $600,000, there's no capital gains taxes. With joint tenancy, only one half of the value at the death of the first spouse gets a new tax basis. So in that example I just gave, one half would get a new tax basis of $300,000, but the other half, the tax basis would be $50,000, or one half of the original $100,000 purchase price. So by holding title as joint tenancy, a married couple can actually end up costing themselves significant capital gains after one spouse dies if the survivor decides to sell the property.
Okay. Okay.
No, good. That's a good tip for folks as they look at that, how they hold title. Another common way to understand that folks hold title here, particularly in California, is in a trust, in the form of trust.
That's correct.
Okay. Perhaps you can tell us a little bit about, what's the purpose of a trust, and what are some of the benefits of having a trust?
Well, what a trust is, it's basically a contract between the person that creates the trust, who agrees with someone to manage the trust, who is usually the same person that created the trust, and they agree to hold the property for the benefit of someone else, which often is going to be the person that's creating it and managing it. So basically it's a contract with yourself, and you create this trust, you transfer in real property, bank accounts, what have you, and as long as you're alive, you manage the trust, you use it for your benefit. When you pass away or become incapacitated, you've had a stroke, you were in a car accident, you name someone else whose job it is to manage the trust. The advantage and the reason why people do trusts is that when you die, there's nothing to go through probate. And what probate is, it's the procedure that title is passed from your estate to whomever the property is supposed to go to. So if you're a single person, you own a house, it's worth $600,000, you die, you have no will or trust, or you have a will, it's still going to go through probate in order to transfer title from your name to whomever you want the property to go to. And a trust avoids all of that.
Okay. And I imagine probate also involves court and legal fees?
Yes, probate is a court proceeding, and basically what happens is that a petition is filed with the court saying someone's died, and we want to name someone as the administrator. Assuming that person is appointed, then we need to inventory the estate, we need to publish a notification that the person has died, and the court has ultimate supervision of everything that happens in that proceeding. And then ultimately, the court will issue an order saying you can go ahead and transfer title to, the kids or, the brother or the sister, whoever's supposed to get the property. Probate's very expensive. A $600,000 estate would generate roughly about $14,000 in attorney's fees, which is pretty significant.
Mm-hmm, mm-hmm.
Yeah.
Let me ask you, going back to the trust, are there some, could there be somebody or some type of people that do not qualify, or that it would not be advantageous to use a trust? What?
Typically, anybody in California that owns real estate should have a trust, because, even if you own property as joint tenants with your spouse or someone else, what happens, the first person dies and then you die. What's going to happen at that point? The property is going to have to go to someone, and if you don't have a trust, it's going to go through probate at some point in time. Okay. If you own less than $150,000 of total assets, whether it's real estate, checking accounts, savings accounts, then you don't need a trust because those are not subject to probate. It falls under kind of the dividing line. Okay. But if you own any real property, especially around here, yes. You're going to need a trust.
Absolutely.
And if you have real property around here that's under $150,000, then
I don't
know anybody who'd want it in the first place.
Well, good. Yeah. So it sounds like not only is there some significant financial savings in terms of that process, but also time as well.
Yeah, it's very correct. Probate will often take about a year from the time that the court appoints the administrator until the time that the court says that everything can be distributed. The other issue with probate is it's a public record. A lot of people don't realize this, but there are actually people that will go down to the probate court and will pull recent filings and will send notices out to either the attorney handling the matter or the heirs, saying that they're interested in purchasing property from the estate, purchasing real estate, whatever it may be. There are people that actually actively market to people that are involved in a probate, and so it's a public record, and a lot of people don't really, understand that, and they don't really want that once they find out about it.
Mm-hmm.
Oh, good. Those are, again, good tips for folks to look into. So we've talked about, how to own property. We've talked about the benefits of a trust and those sort of things. I know you also work with folks not only in putting together their estates, but also issues of aging in place and in looking at qualifying for benefits if folks are in need of that.
The elder law aspect of my practice deals with issues that seniors are going to encounter. And that deals a lot of times with incapacity issues, whether that's someone has a stroke, maybe they have no planning in place, so when you do a conservatorship, or we are looking at being able to protect assets in the event that someone needs nursing home care. And so I do a lot of that.
Okay.
So at what point should somebody plan for that process when they look at their long-term planning? Should they come in and see for their care or elder type of planning?
Well, generally speaking, what I do is if someone's in their 60s or 70s and we're discussing doing an estate plan or reviewing an existing plan, I will then say, we can do a plan that deals with what happens when you die, but what happens if something happens and you can't care for yourself anymore?
Okay.
How would you be paying for nursing home care and other things that you may need? Ideally, they're going to have long-term care insurance. Hopefully they have plenty of money, but not everybody does. Some people around, especially on here, just have a house and maybe $100,000, $150,000 of assets. And if someone needs skilled care, that money's going to go within
about a year and a half.
If that.
My parents have a full-time caregiver, so the cost of that.
And so for those people, what I often will do is I'll ask them, are you planning on staying in your home, until you die, unless again something happens, you have a stroke or what have you. And if they are, and they're not in a situation where maybe down the road they'll need to get a reverse mortgage or something like that, we can look at doing what's called an irrevocable trust for them, where we set up a trust, we transfer the house into the trust, they retain the right to live in the house and ultimately change the beneficiaries who's going to get the house after they're gone, but we name someone else to be the person in charge. And then other than the right to live in the house and the right to any income that may be generated if the house were to, be rented out, we restrict their right to principal. And what this does is that if they ever do need skilled nursing care and they're on Medi-Cal, this will prevent the state after their death from going back in and seeking to be paid back out of the house.
Okay.
And California is actually unique, and it's one of the few states, it's actually the only state that I'm aware of, where you can actually protect the house from an estate claim by the state of California.
Good. So that sounds like that's planning you're doing with people in advance as they're aging. How about if someone is in more of an emergency sort of situation? I'm sure families come to you where there's been, an incident, a crisis situation where maybe a parent's had a stroke or a fall or hospitalization or something along those lines.
Well, again, specifically dealing with real estate in those situations where the person now does not have legal capacity to make decisions, the first thing that I would do is look at what are their existing estate planning documents, their trust, their power of attorney actually allow. Very rarely will those documents allow creation of irrevocable trusts on their behalf, transfer of real property. If that is the case, we can just proceed as if I was dealing with someone who was just worried about having a stroke, not that it actually had one. In most cases, though, their documents are not going to have those provisions, and so we would be looking at either filing a conservatorship and then asking for court permission to do the transfer of the house, or if it's a married couple, there's a specific petition we can file for a married couple where we just go in and ask court, we want to transfer the house from the husband to the wife or from the wife to the husband, and that's all we want to do. And so if the court approves it, they sign the order, and then that case ends, and then we can legally transfer title to the husband or wife.
Okay, well, good.
Well, Jerry, you really are knowledgeable. You've convinced me that you are definitely the expert in estate and elder law. So folks out there that are shopping for an attorney or looking around, what kind of things should they be looking for, questions they should ask, and what information does somebody need to secure an attorney?
Well, I mean, just in general, they should ask things such as how long have you been, in practice. If they want to look at references, I have some clients that I can, refer them to. One thing is the lowest price is not always the best option. And just because you're paying $5,000 for a trust, that doesn't mean that's the best option either. So, it's not really something they should be looking at saving as much money or feeling that they need to pay, a lot of money to get, a good service and a good product. Excuse me. The other thing is, who actually does the work? Is it the attorney that does it, or is it drafted by other people?
Good question, yeah.
Or maybe an attorney does it, but it's presented by an insurance agent, for example.
Okay.
That's very typical when you see these ads in the newspaper for the $300 trust special. If you look at the fine print, it's often going to be delivered by an insurance agent. In many cases with the design of then trying to sell insurance products as well. So, does the attorney just practice in that field? Are they affiliated with, an insurance company? Or are they really going to have someone else, do all the, closing of the documents, if you will?
Okay.
Those are all things to look at.
Good, very good.
Good, those are some fantastic tips for folks. If people are interested in finding out more, perhaps talking to you about their situation, how could they get in touch with you?
Well, they can call me at 408-615-8930, or they're more than welcome to email me at gwc@cummingslegal.com. That's CUMMINGSLEGAL.com. And I do offer a free consultation, and usually about an hour or so.
And you're local here?
I'm in San Jose. I'm very close.
Very close, good.
Yeah.
Good. Well, I'm impressed. Thank you so much for sharing your knowledge, and that's the part of my business that I don't see. I work with title companies, and they really don't advise clients. I recommend my clients to get any legal advice they need in terms of title holding and future planning like that.
Yeah,
so.
Typically title companies just have, everybody hold it as joint tenants because that's how it's always been done, and that's what they tell people to do. And sometimes it's the best route, and sometimes it's not.
It sounds like it may not be, too. So thank you so much for coming.
Thank
Todd,
you.
thank you for bringing our guest.
Well, no, I appreciate you, Jerry, and good advice for folks, and thanks for being our guest today.
Thanks a lot.
All right.